It happens in seconds. A routine encounter, a phone comes out, a camera starts recording, and suddenly everything changes. Voices shift, tension rises, and then the words come, clear, direct, and often intimidating. Put that phone away. In that moment, most people hesitate, not because they want to break the law, but because they don't know where the law actually stands. But here's the question. When a police officer tells you to stop recording, are they enforcing the law or stepping beyond it? Let me know your answer in the comments below. Across the United States, the act of recording police officers in public has become one of the most discussed and legally examined issues in recent years. According to multiple federal court decisions and public records, citizens have increasingly used smartphones to document interactions with law enforcement. These recordings have played roles in court cases, internal investigations, and public accountability discussions. At the same time, law enforcement agencies have expressed concerns about officer safety, interference, and situational control. Departments in various jurisdictions have issued statements acknowledging that while recording may be lawful, it must not interfere with official duties. This distinction between recording and interference is where many legal conflicts begin. According to official court rulings, including decisions from multiple U.S. Circuit Courts of Appeals, there is a recognized First Amendment interest in recording public officials performing their duties in public spaces. However, these rulings are not always identical across jurisdictions, and the scope of protection can depend on context, behavior, and location. One interpretation is that recording police in public is a protected activity under the First Amendment, particularly when it relates to gathering information about government conduct. Another perspective raised in court is that this right is not absolute and may be subject to reasonable time, place, and manner restrictions. This is where real-world confusion often begins. A citizen may believe they are fully within their rights to record, while an officer may perceive the same action as interference or a potential safety risk. Both positions can exist at the same time, and resolving that tension often becomes a legal question rather than an immediate answer on the street. According to public records and documented cases, incidents involving recording have led to lawsuits, internal reviews, and policy changes within police departments. In some cases, plaintiffs have alleged that their constitutional rights were violated when they were instructed to stop recording or when their devices were seized. Departments, in response, have often stated that officers acted within their understanding of the law and in the interest of maintaining control of the situation. This is not a simple issue of right or wrong. It is a legal gray area shaped by constitutional law, court precedent, and evolving public expectations. The First Amendment provides a foundation, but its application depends heavily on context. Courts would likely examine whether the recording was conducted in a public space, whether it interfered with law enforcement duties, and whether any restriction imposed was reasonable under the circumstances. The Fourth Amendment may also become relevant in certain situations. If a recording device is seized, searched, or deleted, courts would examine whether that action constituted an unreasonable search or seizure. These are not abstract legal theories. They are real questions that have been raised in courtrooms across the country. From a legal analysis perspective, understanding what to say and how to say it matters. Not in a confrontational way, but in a calm, informed, and lawful manner. The goal is not to escalate a situation, but to remain within your rights while respecting the boundaries of the law. This is for informational purposes only and not legal advice. Laws can vary by jurisdiction, and outcomes can depend on specific facts. But what remains consistent is this: awareness changes outcomes. In documented incidents, key turning points often occur not when the camera is turned on, but in the conversation that follows. The words exchanged between a citizen and an officer can influence how the situation develops. Tone, clarity, and understanding of rights can all play a role in whether an interaction remains routine or becomes legally significant. For example, in several publicly reported cases, individuals who calmly stated that they were exercising their right to record in a public space without interfering were able to continue recording without escalation. In other cases, misunderstandings about proximity, behavior, or officer instructions led to detentions or further legal action. One perspective is that clear communication helps reduce tension and prevents unnecessary conflict. Another perspective is that ambiguity in the law makes it difficult for both citizens and officers to navigate these situations consistently. Courts would likely examine each case individually, focusing on specific actions rather than general assumptions. As this issue continues to evolve, legal scholars, courts, and law enforcement agencies are all contributing to a broader understanding of where the boundaries lie. Policies are being updated, training is being revised, and public awareness is increasing. But the reality remains. Most people don't learn about these rights in a classroom. They learn about them in real time, often under pressure, in moments that demand immediate decisions. And that brings us back to the central issue. When an officer says, "Put that phone away," the response you give can shape everything that follows, not because it guarantees a specific outcome, but because it reflects your awareness of the law and your intent to act within it. So the real question isn't just what the law says. It's how that law is understood, applied, and communicated in the moment it matters most. As we move deeper into this issue, the focus shifts from theory to practice. What actually happens in that moment when an officer gives a direct instruction to stop recording? And more importantly, how have courts interpreted those interactions when they are later reviewed? According to publicly documented cases and federal appellate decisions, the legality of recording often hinges on one central factor: whether the individual recording is interfering with law enforcement duties. That word, interference, becomes the defining line. But what qualifies as interference is not always clearly defined in the moment. It can depend on distance, behavior, tone, and the overall context of the encounter. One interpretation, supported by multiple court rulings, is that simply holding a phone and recording from a reasonable distance, without obstructing officers or disrupting their actions, generally falls within protected First Amendment activity. Another perspective raised in legal arguments is that officers must maintain control of a scene, and any action perceived as escalating tension could justify instructions aimed at restoring order. This is where communication becomes critical. In my legal analysis, the response given by a citizen in that moment should always prioritize clarity, calmness, and non-escalation. The goal is not to challenge authority in a confrontational way, but to assert awareness of rights while remaining cooperative. Courts would likely examine not just what was said, but how it was said. For example, in several documented incidents referenced in legal filings, individuals who calmly stated that they were recording from a safe distance and not interfering were less likely to face escalation. Their language reflected an understanding of both their rights and the officer's responsibilities. This balance often plays a role in how situations unfold. There is a strong constitutional argument that the First Amendment protects the act of recording public officials performing their duties in public spaces. However, courts would likely examine whether any restriction imposed by law enforcement was reasonable under the circumstances. That includes evaluating whether the officer's instruction was tied to a legitimate safety concern or whether it unnecessarily restricted lawful activity. At the same time, the Fourth Amendment introduces another layer of analysis. If a device is confiscated, searched, or its contents accessed without proper legal authority, courts would likely examine whether that action constituted an unreasonable search or seizure. According to prior rulings, the contents of a phone are generally protected, and accessing them without a warrant can raise serious constitutional questions. This is for informational purposes and not legal advice, but understanding these principles can shape how individuals approach these encounters. Now consider a real-world scenario drawn from publicly available case summaries. A citizen stands several feet away from a traffic stop, recording quietly. The officer notices and instructs the individual to step back further. The individual complies, continues recording, and calmly states that they are not interfering. In many such cases, the situation remains controlled and no further action is taken. Contrast that with another scenario. A person records while moving closer, speaking loudly, or interrupting the interaction. In those situations, officers may argue that the behavior crosses into interference. Courts reviewing these cases often focus on specific actions rather than the mere act of recording. These examples highlight a key point. The law often depends less on the presence of a camera and more on the behavior surrounding it. From a legal standpoint, one of the most important turning points in these encounters is the moment of instruction. When an officer says, "Put that phone away," it introduces a legal question. Is this a lawful order based on safety or interference, or is it a restriction on a protected activity? Courts would likely analyze several factors. Was the individual in a public space? Were they maintaining a reasonable distance? Did their actions interfere with the officer's duties? Was the officer's instruction narrowly tailored to address a specific concern? There is no single answer that applies in every situation. That's what makes this topic both important and complex. In my legal analysis, the most effective responses are those that acknowledge the officer's authority while clearly expressing lawful intent, not in a defiant tone, but in a measured and respectful way. The objective is not to win an argument in the moment, but to avoid escalation while preserving rights. This is where many misunderstandings occur. People often assume that asserting a right requires confrontation. In reality, courts tend to look more favorably on individuals who remain calm, non-threatening, and cooperative, even while asserting their rights. From the law enforcement perspective, officers are trained to assess risk quickly. A camera may not be a threat, but the behavior of the person holding it can influence how the situation is perceived. Departments have increasingly incorporated training on citizen recording, but application can still vary from one officer to another. According to official department policies released in several jurisdictions, officers are often instructed that recording is allowed as long as it does not interfere. However, these policies also emphasize officer discretion in maintaining scene control. That balance, policy versus discretion, is where many legal disputes arise. Another important aspect is location. Courts have generally recognized stronger protections for recording in traditional public forums, such as streets and sidewalks. However, restrictions may be more enforceable in private property, secured areas, or locations with specific legal limitations. This distinction becomes critical when analyzing whether an instruction to stop recording is lawful. Courts would likely examine whether the location itself imposed any restrictions independent of the officer's command. As the legal landscape continues to evolve, appellate courts have played a major role in shaping how these cases are understood. While not all circuits have identical rulings, there is a growing recognition of the right to record, balanced against legitimate law enforcement needs. In my view, one of the most important long-term developments is the increasing clarity around this issue. As more cases are decided, both citizens and law enforcement gain a better understanding of where the boundaries lie. But until those boundaries are universally defined, situations like these will continue to depend heavily on individual judgment in real time. And that brings us back to the central idea. When a moment of tension arises, when a simple instruction is given, the outcome is often shaped not by the law alone, but by how that law is communicated and understood in the moment. So think about this carefully. If you were in that situation, standing there, phone in hand, being told to stop recording, how would you respond in a way that is calm, lawful, and informed? Let me know your answer in the comments below. Your perspective adds to this discussion and helps others think through these real-world situations more clearly. As we move toward the final part of this discussion, everything comes down to one practical reality. In these moments, there is no pause button. There is no time to research case law or review constitutional text. What you say, how you say it, and how you carry yourself all happen in real time, and they can influence the entire direction of the encounter. According to multiple legal analyses and publicly available case records, the most consistent factor in avoiding escalation is not the camera itself, but the conduct of the person holding it. Courts would likely examine demeanor, distance, tone, and intent. These are not abstract legal concepts. They are real-world behaviors that can either de-escalate or intensify a situation within seconds. In my legal analysis, one of the most effective approaches is calm, clear, and respectful communication. Not silence, not confrontation, but controlled, informed speech. The purpose is not to challenge authority, but to demonstrate awareness of the law while remaining cooperative. There is a strong constitutional argument that recording public officials in public spaces falls under First Amendment protections. At the same time, courts would likely examine whether any restriction imposed by law enforcement was reasonable in light of safety concerns or operational needs. That balance is where most legal outcomes are decided. So what does that look like in practice? In documented encounters, individuals who maintained a respectful tone and clearly communicated that they were not interfering often avoided escalation. Statements that emphasize distance, compliance with lawful instructions, and a non-disruptive presence were frequently noted in legal reviews as factors that helped stabilize the situation. Another perspective raised in court is that officers are given a degree of discretion in maintaining control. That means even lawful behavior can be temporarily restricted if it is reasonably believed to interfere with duties. Courts would likely examine whether that belief was justified based on the circumstances at the time. This is why clarity matters, not aggressive language, not emotional reactions. but simple, measured communication that reflects understanding. At the same time, the Fourth Amendment remains relevant. If a situation escalates to the point where a device is taken or searched, courts would likely examine whether proper legal standards were followed. The protection of personal data, especially on digital devices, has been consistently recognized as a significant constitutional concern. This is for informational purposes only and not legal advice, but one principle stands out across nearly all cases. The more controlled and informed the interaction, the more likely it is to remain within legal boundaries without escalation. Now consider the broader implication. This isn't just about one moment or one interaction. It reflects a larger shift in how public accountability, technology, and law enforcement intersect. Cameras are now part of everyday life. The law is still adapting, and both citizens and officers are navigating that reality together. Supporters of recording rights argue that transparency strengthens accountability and public trust. Law enforcement perspectives often emphasize safety, order, and the need to manage unpredictable situations. Both viewpoints exist within the legal system, and courts continue to weigh them carefully. In my view, the most responsible path forward is awareness, not assumption, not reaction, but understanding, knowing where your rights begin, where limitations may apply, and how to act in a way that respects both. Because at the end of the day, the goal is not to create conflict. The goal is to stay within the law, protect your rights, and ensure that the situation does not escalate unnecessarily. And that brings us back to the core idea behind this entire discussion. When an officer says, "Put that phone away," the moment that follows is not just about recording. It's about judgment. It's about awareness. It's about how the law is applied in real time. So now I want to leave you with this final question. Given everything we've discussed, do you believe these situations are more about misunderstanding the law or about how the law is enforced in the moment? Share your thoughts in the comments below. Your perspective matters, and it adds real value to this conversation. If you found this video helpful and want more clear, professional breakdowns of real legal situations, make sure you subscribe to the channel, press the bell icon so you don't miss any future updates, and most importantly, tell me in the comments what topic you want me to cover next, because the more informed you are, the better decisions you can make when it matters most.